Hello and good morning. I am Dr. Manvendra Kumar Tiwari, Associate Professor, Dharmashastra National Law University, Jabalpur. Today, we will discuss in the legal reasoning part some of the questions on fundamental rights and, in particular, right to equality. We will primarily be looking at the two provisions of the Constitution, that is, Article 13 of the Constitution and Article 18 of the Constitution. Article 13 of the Constitution of India talks about laws inconsistent with or in derogation of the fundamental rights. And it states that any law which is inconsistent or in derogation of the fundamental rights, the extent of that inconsistency or derogation is void, which means that it ceases to be law. Now we'll see what Article 13 contains. As you can see, Clause 1 of Article 13, it says, all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part. And this part here means the fundamental rights part. And in our Constitution, the fundamental rights are provided in Part 3 of the Constitution. And that is why I have mentioned Part 3, fundamental rights, within bracket after the word part. And it says, shall to the extent of such inconsistency be void. What is important to note here is that Article 13, Clause 1, is actually referring to laws which were already in force in the territory of India at the time of commencement of the Constitution of India. So, as the future students of law, you must know that the laws that exist in India are not all the laws actually come into effect or operation after 26 January 1950, the day when the Constitution started operating formally. But we have had laws operating even before 26 January 1950. And those laws continue to operate even after the commencement of the Constitution of India. Therefore, Constitution in Article 13, when it provides for a bar that the fundamental rights cannot be violated by laws, the first clause of Article 13 says that even the laws already in force in India, that is pre-constitutional laws, even such laws cannot violate fundamental rights. That is one important pointer that we need to keep in mind. Okay, so when you come across laws like Indian Contract Act 1872, when you come across laws like Transfer of Property Act 1882, and even till very recently we had Indian Penal Code 1860, recently replaced by Bharatiya Nyaya Sanhita. But till last year, we had Indian Penal Code 1860. These were pre-constitutional laws enacted during the British era. And yet these laws continued even after the commencement of the Constitution. But at the same time, what is important to keep in mind is that if the Constitution, when it came into effect on 26 January 1950, it stated that even though the pre-constitutional laws will continue, but the pre-constitutional laws must also be consistent with the fundamental rights. And the fundamental rights came into existence from 26 January 1950. That is important. So if you have heard about, say, for example, the Navtej Singh Johar judgment of the Supreme Court of India, where the Supreme Court, by a constitution bench, 5-judge constitution bench of the Supreme Court, declared the provisions of the Indian Penal Code, which provided for consensual sex among the people of same sex to be an offense. Supreme Court declared that provision to be unconstitutional. So 377 of the Indian Penal Code was actually a pre-constitutional provision, and therefore it falls in Article 13, Clause 1. And according to the mandate of Article 13, Clause 1, pre-constitutional law must also be consistent with the fundamental rights. The Supreme Court in Navtej Singh Johar found that Section 377 of the Indian Penal Code in its entirety is not consistent with the fundamental rights provided in the Constitution of India, primarily Article 21 of the, which guarantees right to personal liberty. So, because Section 377 was not consistent with Article 21 and Section 377 of Indian Penal Code being a pre-constitutional law, it must follow the mandate of Article 13, Clause 1, failing which can be declared unconstitutional. The same thing happened in Navtej Singh Johar, where the Supreme Court of India found Section 377 to be inconsistent, and therefore to the extent of that inconsistency, it was declared unconstitutional and hence void. So that is how we need to understand Clause 1. Next is Clause 2. Now, Clause 2 says that the state shall not make any law which takes away or abridges the rights conferred by this part. Again, that is Part 3, Fundamental Rights. And any law made in contravention of this clause shall, the extent of the contravention, be void. Now, Clause 2 of Article 13 is specifically talking about laws that will be made after the commencement of the Constitution by the legislatures in the independent India, be it the Parliament of India or the state legislatures. And it again states in no uncertain terms that a law made in independent India that will be post-constitutional law. So the post-constitutional laws must also be consistent with fundamental rights. If not so, then to the extent of inconsistency with fundamental rights, the laws so made shall be declared to be unconstitutional and hence void. So Clause 2 is about laws that will be made after the commencement of the Constitution. Now, Clause 3 of Article 13 explains, it gives us an inclusive list of what law means in these two clauses. As the students, again, as the future students of law, you must know that the law is not only, the term law is not only covered by the legislations enacted by the legislature. Law is a broader term, and therefore it refers to what law means here, and it says it includes. So this is not an exhaustive definition. Even the new forms of law can be read into Article 3, and that is why it is in illustration form, and that is why the use of the word includes. So law includes any ordinance. Ordinances are made by the President of India or the governor of respective states when the legislature is not in session and there is a pressing need for making of a law. So for that interim period, an ordinance is promulgated by the president or the governor, which subsequently, when the legislature comes in session, has to be formally adopted in the form of legislation. That is what ordinance means. The next we have order, bylaws, rule, regulation, notification. Now, order, bylaw, rule, regulation, notification. These are examples of what we know as secondary legislation or delegated legislation. Secondary legislations or delegated legislations, also called executive legislation. Now, these are the legislations which are actually made by the executive, but not the president or the governor. Rather, these are made by the respective ministries who have the primary responsibility of the implementation of a legislation. The legislations provide for the room for making of these bylaws, rule, regulation, notifications, and orders. And these are subsequently, after the law is enacted by the legislature, the respective ministries come up with these order, bylaw, rule, regulation, notification. The nomenclature may vary, but the but these are all put under one general category of delegated legislations or subordinate legislation or executive legislations. These are also laws, but these are not the laws enacted by the legislature. Rather, these are the laws made by the executive, deriving the authority to make the law from the primary law that has been enacted by the legislature. So the primary law delegates this authority to the executive to do so, and following the mandate, the executive makes these secondary legislation. So even a secondary legislation must be consistent with the fundamental rights. That is what is the mandate here under Article 13 of the Constitution. Apart from that, if you see what all law includes, it also includes custom or usage having in the territory of India the force of law. Now, this is important. When we study about custom or usage, we know that customs or usage, there are many customs and usage in India which has the force of law. But according to Article 13 and specifically Article 13 Clause 3, and customs are more likely to fall in laws enforced, that is Article 13 Clause 1, because the custom is more likely to be operational from pre-constitutional era. So what it therefore says, that even customs or usages must be consistent with fundamental right, because even the custom and usages are included under the definition of law. Therefore, a custom, if it is against the fundamental right, that custom also ceases to be law from 26 January 1950. However, another thing that we need to keep in mind that the courts, that is the Supreme Court and the High Court, need to formally declare that a law is actually inconsistent with the fundamental rights. Therefore, there is no automatic invalidation of laws. There has to be a formal declaration of unconstitutionality by the Supreme Court or the High Court for Article 13 of the Constitution of India to be pressed into service. So that is how we understand these provisions. Now, apart from that, Clause B of Article 3 also tells us what is the meaning of laws in force. As we saw that Article 13 Clause 1 refers to laws in force in the territory of India at the time of commencement of the Constitution. So again, it explains what that laws in force means, and it is again an inclusive definition, which means it is an illustrative list, and new things can also be read into laws in force. So we'll see what it says. Laws in force includes laws passed or made by the legislature or other competent authority in the territory of India before the commencement of the Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be in operation either at all or in particular areas. Okay, so laws in force includes laws passed or made by the legislature or competent authority in the territory of India before the commencement of the Constitution and not previously repealed, as we already saw it. Here, one thing which is important, which has actually come from judicial interpretation, there was in 1951, there was a judgment of Bombay High Court in Narasu Appamali versus State of Bombay. The Bombay High Court had to answer the question whether an uncodified personal law is also law in force under Article 13 or not, meaning thereby whether a Hindu law or Muslim law, which is not a statutory Hindu law or Muslim law, for example. In this case, the question was about Muslim law. You would know when you will become formally the students of law that Muslim law in India permits bigamy. Bigamy means that a man can have more than one wives, without the need of first dissolving the existing marriage, as per the Islamic personal law. And this is an uncodified Islamic personal, meaning thereby this law has not been made by any competent legislature, rather based on the interpretation of the Islamic religious texts. This has been construed to be the existing Islamic law. So therefore the question was, if the Hindu law is prohibiting, if the Hindu statutory law is prohibiting bigamy, making it an offense, as was the case in Bombay then, because the state of Bombay had enacted a law making bigamy among Hindus an offense. So the question was whether the state can do that, where for Muslims, it will not be an offense, whereas for Hindus, it will be an offense. The question was whether the law is violative of Article 14, that is right to equality, by actually making this an offense for Hindus and not an offense for Muslims. So this question could only have been decided if the Bombay High Court would have come to the conclusion that the laws in force at the time of commencement of the constitution, in this case the Islamic personal law, which permitted bigamy in Islam for Muslim male, whether it is a law under Article 13(3)(b), laws in force or not. Okay? So whereas the other side's argument, the government's argument would be that there is hardly any difference between an uncodified personal law and a custom or usage. If a custom and usage cannot violate fundamental rights, certainly uncodified personal laws also cannot violate fundamental rights. But the Bombay High Court in this case decided that even though custom and usage are actually included in the definition of law, the uncodified personal laws are not. And the court primarily said so based on its reading of Article 44, which provides for uniform civil code in the Constitution of India, which is a legislative mandate for the legislature to make law, thereby addressing these anomalies that exist in personal laws. So the court recognized that since this is a legislative mandate and not a judicial mandate, therefore it would be wrong on the part of the courts to read in uncodified personal laws also under the definition of law, making uncodified personal laws amenable to judicial challenge on the ground of violation of fundamental rights. And therefore, the Bombay High Court decided that an uncodified personal law is not laws in force at the time of commencement of the. And therefore, even though, and there is an argument that an uncodified personal law is inconsistent with the fundamental rights, that alleged inconsistency cannot be challenged in a court of law, because that solution has to be provided by the legislature as per the Constitution of India, following the mandate of Article 44 of the Constitution of India. Okay, I'll again repeat the name of the judgment. This is Narasu Appa Mali versus State of Bombay. So this was an important judgment that you must know. Of late, this judgment has been criticized by the Supreme Court on many occasions, where the court has felt the need for revisiting this judgment, but the judgment so far has not been overruled by the Indian courts. And even though it's a Bombay High Court judgment, even the Supreme Court recognizes this to be the law of the land. Now, finally, Clause 4 of the Constitution, which is actually added in Article 13 by a constitutional amendment. And it says nothing in this article shall apply to any amendment of this Constitution made under Article 368. That means this is also telling us what is not included in the definition of law. What is not included in the definition of law so far as Article 13, Clause 2 is concerned, which talks about laws made after the commencement of the Constitution, which cannot be inconsistent with fundamental rights. So Clause 4 is categorically saying that if a constitutional amendment is actually attempting to do something whereby the constitutional amendment, which is also a law, is actually providing for something which is inconsistent with the fundamental right, that constitutional amendment cannot be challenged as an unconstitutional law. Therefore, it is making it clear that a constitutional amendment is not law under Article 13, Clause 2. As I said, this was added later on after a constitutional amendment. We'll talk about it later when we will, in our future recordings, we'll talk about Article 368, which provides for the amendment of the Constitution. Then we'll refer to it later. But as of now, since we are also trying to understand how to read and interpret the law, so therefore our understanding from Clause 4 is that a constitutional amendment is not law under Article 13, Clause 2. Hence, a constitutional amendment, if it is inconsistent with fundamental right, and we must know that a constitutional amendment is also law. But if a constitutional amendment as law is inconsistent with fundamental right, that inconsistent law inserted by a constitutional amendment will remain valid and it will not be void on account of inconsistency with fundamental right, because this has been categorically provided by Article 4, which says what is excluded from the definition of law under Article 13(3)(a), and hence consequently that also gets excluded from the meaning of law under Article 13, Clause 2. Now we'll see some questions based on Article 13. So the first question is, laws in force in the territory of India immediately before the Constitution. Laws in force in the territory of India immediately before the commencement of this Constitution are void. Now we saw it's the Article 13, Clause 1 says, only the laws in force at the time of commencement of this Constitution which are inconsistent with the fundamental rights, to the extent of such inconsistency, are void. That means they are not in its entirety void. Now, if you look at the options after the commencement of the Constitution, so this will not be the right answer. Insofar as they are inconsistent with the provisions of this part, that is fundamental rights, to the extent of such this appears to be right. However, we must also rule out the other two options. Before the commencement of the Constitution, this cannot be the right answer. After the commencement of the Constitution, if not repealed by the Parliament, also cannot be right. So the right answer is Clause B, insofar as they are inconsistent with the provisions of this part, to the extent of such inconsistency. Clause 2. The state shall not make any law which takes away or abridges the fundamental rights conferred by this part. That is part 3. And any law made in contravention of this part, again, I think it follows from 13.1. This follows from 13.2. To the extent of the contravention be void. Be void to an unlimited extent? No, because Article 13 categorically says the laws are only void to the extent of inconsistency and not to an unlimited extent. Therefore, Clause B cannot be right. Shall remain valid. This is obviously wrong. Shall remain in abeyance. This is again wrong. So option A is the right answer. In this article, unless the context otherwise requires, law does not include. What is excluded from the definition of law? Okay. Now, if you look at any ordinance covered, order, bylaw, rule covered, regulation, notification covered, custom or usage not having the force of law in the territory of India. Obviously, custom or usage having the force of law is included. But custom or usage not having the force of law, this is so clearly Clause D is the right answer, because for all A, B, C are included the definition. Okay. Not having the force. Custom or usage must have the force of law as per Article 13(3)(a). Clause 4. A law enacted to amend the Constitution of India is void if it violates the fundamental right to the extent of inconsistency. This cannot be right. Not void if it violates the fundamental rights to the extent of inconsistency. This appears to be right. Fundamental rights can be validly amended by constitutional amendment if the amendment does not violate the basic structure of the Constitution. Article 13 does not refer to basic structure, and that's why we cannot go into this clause. Now, why is this important? This is also in a way is a trick question, right? Because you have been given a passage. Take Article 13 to be a passage. You have been given a passage and you have to give the answer from the passages and not from the knowledge that you have in addition to the passage. Now, if you look at the passage, Clause 4 of Article 13 clearly states that in the definition of law, constitutional amendments are not included. The effect would be that a constitutional amendment can validly violate fundamental right, and even then the constitutional amendment will be valid. Whereas the law as it stands today after 1973 that is the Keshwan and Bharati judgment, that says that a constitutional amendment, in order to be valid, must not violate basic structure. But this is not given in the passage, and therefore you should not understand that clause C is the right answer. Clause C will not be the right answer here, because we have to answer based on the passage given. And the passage clearly says, as per clause 4, that that a constitutional amendment is not void even if it violates fundamental right. That's why, and there is no reference of basic structure in the clause. And therefore, you should not be in a hurry to supplement your answer based on your prior understanding of the correct situation. It is a question based on passage. Therefore, the answers must follow and flow from the passage, and that's why not clause C cannot be the right answer, though we know that after Keshwan and Bharati judgment, clause C is the right answer. But the passage nowhere talks about Keshwan and Bharati, and that's why you should refrain from saying that clause C will be the right answer. Finally, void regardless of its consistency or inconsistency. Again, basic structure is used. So clause B, not void, if it violates the fundamental right to the extent of inconsistency. This is the right answer. Now, fifth question. Parliament of India enacts a law to repeal a custom having the force of law. Such a law is, now the question is whether Parliament can repeal a custom. Valid because a law made can repeal custom. This appears to be right. Void because a law cannot repeal custom. This is not written there. Valid if it is consistent with fundamental rights. Void even if it is consistent with fundamental rights. So B and D are ruled out, not void. The question is valid because it is a law that a law made can repeal. Now, the first option is not discussed in Article 13, but if you look at clause C, valid if it is consistent with fundamental rights. This is squarely covered by the mandate of article. A law made, Article 13(2). How will an Article 13(2) law be valid? If it is consistent with fundamental. What it does, whether it is repealing customs or what, that is not relevant. What is important is that a law must not be violative of fundamental. And clause C, valid if it is consistent with fundamental right. So option C will be the right answer. Now come to Article 14. Article 14 to 16. 14 provides for a generic right to equality, and 15 provides for no discrimination based on race, caste, gender, religion. So it categorically says that there cannot be discrimination based on these aspects, whereas 14 provides for that there shall be equality before law and equal protection law. So the 14 is the substantive is the generic right, whereas 15 and 16 are specific instances of right to equality. 16 primarily talks about no discrimination in case of public employment. Okay, so facets of right to equality. Obviously, a discussion about Article 14 would take a lot of time, but here our purpose is simply to understand a few basic things about right to equality. Now, first of all, formal equality. Now, what do you mean by formal equality? Formal equality is that everyone should be treated equally. That means no person should be treated differently. Now, that is how we understand formal equality, that if there is unequal treatment, if somebody is favored or somebody is adversely treated, then that amounts to violation of equality. That is what we call formal equality, that everyone is to be treated equally. No favor, no discrimination. That would be the understanding of formal equality. Obviously, Article 14 strives for formal equality, but Article 14 is not exhausted by formal equality. And that is why we also need to understand what is substantive. Article 14, that is equality as a substantive right. Now, or substantive equality. What does that mean? Now, substantive equality would mean that Article 14 or 15 or 16 not be considered just as vehicles of right to equality. Article 14 are actually 14, 15, and 16 there is a goal inherent in these rights, which are to strive for an egalitarian Indian society. If that be the case, egalitarian Indian society, if that be the case, since the people who are part of Indian society are not equal, there is huge disparity among them. Therefore, a formal equality where everyone is to be treated at par, no favor, no discrimination, would probably be unfair for the people who are not at par in the mainstream of the Indian society, who have lagged behind considerably owing to historical reasons associated with caste, associated with their financial status, associated with their class, associated with their gender. So, therefore, what substantive equality right recognizes that if there is a preferential treatment of such people who are way below the ladder in the social hierarchy, then giving preferential treatment to them will not be considered violation of right to equality, because a preferential treatment is contrary to formal right to equality. And therefore, we need to keep in mind the purposive understanding of right to equality, which is to actually strive for an egalitarian society. So, therefore, preferential treatment is not contrary to right to equality. So, giving reservation in employment in government jobs not considered per se violative of right to equality, because reservation is being given to people who are lagging behind in the social hierarchy, and that is why, in order to uplift them, bring them into the social mainstream, reservation is being given. If reservation is given to women, for example, if reservation is given to transgender, now this reservation recognizes that owing to the gender, uh, the dominance of male, in our society, which many of us refer to as patriarchal society, uh, male gender has remained preferred gender, and because of that, the other gender, that is the female gender and the transgenders, they have they have been lagging behind in the social hierarchy compared to the male gender. And that is why there is a need for preferential treatment for women. There is a need for preferential treatment for transgender. So, if giving of reservation in government jobs to transgenders, to women, will therefore not be considered contrary to formal right to equality or right to equality in general, because that is actually to bring people who are marginalized into the social mainstream by providing that preferential treatment is actually recognizing equality as a substantive right, and not just as a formal right which guards against any preferential or discriminatory treatment. This therefore remains the logic for reservation. This therefore remains the logic for any preferential treatment to anyone, any section of the society, or to any individual. The primary reason for that preferential treatment is because that person or the community or the group happens to be marginalized, happens to be lagging way behind in the social hierarchy compared to that group or individual that has been privileged, okay, for reasons historical. Okay, so that is how substantive right to equality is. So, in 4, for example, provides for the basis for the grant of reservation. So, when 16.1 prohibits preferential treatment in public employment in government jobs based on any yardsticks, 16.4, caste becomes the yardstick for preferential treatment, caste-based reservation. So we understand that 16.4 is not an exception to 16.1, which prohibits any preferential treatment based on caste. 16.1 would prohibit preferential treatment based on caste, whereas 16.4 provides for preferential treatment based on as it is understood. So the one understanding based on formal right to equality would be that 16.4 is an exception to 16.1. But the correct understanding is that 16.4 is not an exception to 16. Because 16.1 is also talking about an egalitarian Indian society. And therefore 16.4 is again trying to ensure that. Therefore, two are not contrary to each other. Not understand formal right to equality and substantive right to equality as contrary to each other. Both are actually meant to subserve the purpose of bringing about an egalitarian society. And that is how we must understand right to equality. Now, coming to the third aspect of right to equality, which is about non-arbitrariness. This has actually come from a judicial interpretation of the Supreme Court in E.P. Royappa versus State of Tamil Nadu judgment, where the Supreme Court stated that any action which is arbitrary is an unequal treatment. Therefore, an arbitrary action violates Article 14. Now, this is a new facet. Why? Because prior to this, we used to understand violation of Article 14 as instances of discrimination. Now, what may happen because of this, that the entire group may be discriminated. That means nobody has been preferred. But if the action is arbitrary of discriminating the entire group, that means not favoring anyone. So there is no discrimination vis-a-vis. Everyone has been treated equally. But if the action itself is arbitrary, where everyone has been treated equally but arbitrarily, even then the court would declare it to be violation of Article 14. That's a new facet where discrimination is not to be proven. What is to be proven is that the action is an arbitrary action. It is devoid of any rational basis. If that can be proven, that act can also be declared unconstitutional, regardless of the consequence, whether someone has been discriminated by that action or not. That is also an important facet of right to equality. Now, we'll see a passage based on our understanding of right to equality. This is from recent judgment, report of a recent judgment on the EWS reservation, economically weaker sections reservation, was inserted in the Constitution of India by 103rd Constitutional Amendment. Prior to this, we only had caste-based and gender-based reservations. So this is for the first time in 2019 that the Government of India decided, Parliament, to bring reservation based solely on economic status. And it also excluded the caste-based beneficiaries from the purview of economically weaker section, meaning thereby that if a scheduled caste candidate is also economically weaker, that scheduled caste candidate will not have the benefit of taking the EWS reservation. Scheduled caste candidate will only get the scheduled caste reservation and not the economically weaker section reservation. So this EWS reservation is therefore exclusively for people who were otherwise not beneficiaries of reservation in the caste-based reservation mechanism that we used to follow prior to 2000. So this was inserted, and this was challenged before the Supreme Court of India, and the Supreme Court 5-judge constitution bench in Janhit Abhiyan versus Union of India delivered a split 3-2 verdict declaring this amendment to be constitutional. Now, as it says, in a 3-2 verdict, the Supreme Court upheld the economically weaker section reservations introduced through the Constitution 103rd Amendment Act 2019. This amendment allows the states to make reservations in educational institutions and in matters of public employment on the basis of economic criteria alone. All 5 judges agreed that the Constitution permits reservation based solely on economic criteria, agreed on who can avail EWS reservation and how many seats may be reserved. Okay, so all 5 judges agreed that there can be a solely economic criteria for the grant of reservation of the Constitution. But they disagreed so far as exclusion of caste-based beneficiary within the fold of EWS is concerned, and to the extent the seats may be reserved in excess of 10. So that was the reason for the split between the majority and the minority set of judges. Justice Dinesh Maheshwari, Bela Trivedi, and J.B. Pardiwala upheld the amendment in its entirety, in separate concurring opinions. Separate concurring opinions means the judges have written their own opinions, and there is no just one majority judgment on which the other two judges have signed. All three of them have written their own judgments. But this is what, in its entirety, they have said. They stated that the economic criteria for reservations is constitutionally valid. Justice Maheshwari explained that the reservations are an affirmative action measure to counter not just social and educational backwardness, but all sorts of disadvantage, and therefore an economic disadvantage can also be addressed through reservation. All three judges found that SC, ST, and OBC citizens can be excluded from the scope of EWS reservation. Three judges, we are talking about majority. Justice Trivedi noted that EWS is a category of disadvantage of its own. Just as equals cannot be treated unequally, unequals cannot be treated equally, she clarified. The majority further found that the 10% EWS reservation in excess of existing 50%. Now, what is important is that EWS reservation meant that the reservation will, in government jobs or in admission to government institutions, will go up to 60% from 50, 10% for EWS. And as set out in Indra Sani has set out a 50% limit for reservation. So, 103rd constitutional amendment, which provided for EWS reservation, exceeded that limit. So, the majority of three judges said that it held that the 50% limit is a flexible limit. It may be breached in extraordinary situations. More importantly, they found that 50% limit applies only to reservations for socially and educational backward classes, not to all type of reservations. So, they are saying that 50% reservation meant 50% reservation so far as socially and educationally backwards are concerned. Economically backwards, if there is additional seats reserved for economically backward, that is not covered under the 50% limit for the majority. On the other hand, Justice Ravindra Bhatt, writing for himself, and Chief Justice UU, now these two are the judges in minority, found the concept of EWS reservation itself permissible, but held that the amendment is unconstitutional. Expressing his dissent, he stated that this court has, for the first time in several decades of republic, avowed an expressly discriminatory principle. The amendment's language of exclusion undermines the fabric of social justice and the basic structure of the Constitution. Justice Bhatt held that the exclusion of SC, ST, and OBCs from the EWS reservations violates the basic structure of the Constitution. Referring to Major Sinha Commission report, he stated that a bulk of economically disadvantaged sections of India belong to the backward classes. It is delusional, he said, to presume that these socially and educationally depressed classes have an advantage for the forward caste poor only because they have caste-based reservations. So this slide is actually telling us the reasons why the minority disagreed with the majority. Justice Bhatt and Lalit further found that the amendment is unconstitutional because it allows the government to exceed the 50% limit on reservations as established in the Justice Bhatt held that allowing EWS reservations to exceed this limit will become a gateway for further breaches, leading to compartmentalization. And this passage has been taken from Supreme Court of. Now, first question based on this passage: reservation based solely on economic criteria was declared constitutionally valid by all five judges. We know that. That is what is categorically written in the first para of the passage itself. Justice Maheshwari, Justice Pardiwala, and Justice Trivedi upheld the constitutional amendment in parts to the extent in its entirety. That is why the judgment, that is why the amendment was valid. So, option C is the right answer. On the other hand, Justice Bhatt, in writing for himself, and Chief Justice Lalit found the concept of EWS reservation itself permissible, but held that the amendment is constitutional, unconstitutional, partly constitutional, constitutional to the extent it excluded. As you saw in the passage, they said that so far as amendment is concerned, it is okay. So clause option B is the right answer. For the minority, the amendment is unconstitutional because it excluded caste-based beneficiaries and it exceeded the 50% limit for the reservation. Justice Ravindra Bhatt stated that to presume that these socially and educationally deprived classes have an advantage over the forward caste poor only because they have caste-based reservation benefit is delusional. This is from the paragraph, directly taken from the paragraph. So thank you. This is so far as Article 14 is. in the next slides, next recordings, we'll see some of the other important fundamental rights. Thank you very much.